De Silva against the license authority of Trinidad and Tobago and another.
Yes, Mr. Rodriguez.
Good morning, my lords and my lady. May it please you, I am Christoph Rodriguez. I appear for the appellant in this matter along with Mr. Devon Williams. We are instructed by Ms. Kimada Utley. Mr. Rowan Pennington Benton appears for the respondent in this matter, and he's instructed by the firm Charles Russell. May I proceed, my lord?
Yes, please do, Mr. Rodriguez.
Oh, grateful. My lords and my lady, I propose to deal with this appeal in this way. I will take you through the case for the appellant, and at the same time, I will deal with my friend's argument. Because it's a short point of construction, I don't intend to take you through our case and then deal with their case. I think that we can just deal with all at the same time. So the first question I propose to deal with is whether the High Court of Trinidad and Tobago is a court of competent jurisdiction for the purposes of Section 88M9 of the 2017 Amendment to the Motor Vehicle and Road Traffic Act. So the background to this appeal is that the judge of the High Court, Justice Sipasad, dismissed the appellant's appeal on the basis that the appeal was lodged before the wrong forum. The judge declined jurisdiction and held that the Court of Appeal was the correct forum for appeals under Section 88M9 of the 2017 Amendment to the Motor Vehicle and Road Traffic Act. Now, as the Court is fully aware, Section 88M9 gives a person a right of appeal to a court of competent jurisdiction. Presumably, then, a person can avail himself of this right of appeal before any court of competent jurisdiction, because the legislation says a court of competent jurisdiction. It doesn't refer to the court of competent jurisdiction. So any court that satisfies the requirements of a court of competent jurisdiction, we say that the appellant can avail himself of his right of appeal before that court. We say that a court of competent jurisdiction is one which has jurisdiction over the person, the subject matter, and can give the remedy that is being sought. And in that regard, we rely on the authority of the Canadian Supreme Court of Hines, which can be found at page 2401 of the electronic bundle. In particular, page 2388 of the electronic bundle. But what I say here about a court of competent jurisdiction is a rather simple point. A court of competent jurisdiction is one which has the jurisdiction over the person, the subject matter, and can give the remedy that is being sought. In this respect, then, we submit that the High Court of Trinidad and Tobago fulfills all the requirements of a court of competent jurisdiction. We also say that the Court of Appeal of Trinidad and Tobago stands in no better position than the High Court, since both courts under Section 88M9 suffer from not having an express grant of legislative authority to hear appeals. So when one looks at Section 88M9, you would see that it doesn't refer to any particular court. We say then that both the High Court and the Court of Appeal both are suffering from an express grant of legislative authority. So neither court has been specified by the legislature to deal with appeals under Section 88M9. However, the rules of court of Trinidad and Tobago, the civil proceedings rules of Trinidad and Tobago, envisage that the High Court can and will deal with appeals from inferior tribunals, such as the licensing authority. So what we say here is that Part 60 of the civil proceedings rules of Trinidad and Tobago, which can be found at 2701 of the electronic bundle, that part envisages that the High Court of Trinidad and Tobago can hear appeals from inferior tribunals.
I don't think there is.
There isn't a 2701 in my bundle.
My lords, if I may have a minute. What is it?
The rules.
The rules.
Supreme Court.
2071. My apologies.
2071
of the electronic bundle. I did say 2701. So it's 2071.
But this is only the procedure for dealing with appeals, if there are appeals, isn't it?
Indeed, so please, my lord. But what we say is that the rules of court envisage that the High Court will be a court that can deal with appeals from inferior tribunals, such as the licensing authority under the Motor Vehicle and Road Traffic Act. And I say this against the background that both Court of Appeal and the High Court are suffering from a lack of express legislative grant. So the Court of Appeal is in no better position than the High Court here.
So are you saying that they both have jurisdiction?
They both have jurisdiction. Or potentially both can have jurisdiction.
I thought your case was that the Court of Appeal jurisdiction was limited to what the statute says. And
So this is where we get to that point. I'm saying that when one looks at the legislation and when one looks at the rules of the Supreme Court, one can imagine that both courts can have jurisdiction. But upon a proper construction of the legislation, we get to the point of saying that the High Court is the court with jurisdiction and not the Court of Appeal.
Oh, okay.
Right, but I think you also told us that there is no statutory provision giving the High Court appellate jurisdiction from the licensing authority.
That is correct, please, my lord.
Well, presumably there are some examples, are there, of statutes which do provide for appeals to the High Court?
Indeed, please, my lord. I can provide those to you once I have an opportunity to look at it.
Right.
But there are definitely statutes which give the High Court appellate jurisdiction.
I'm just not sure how we're assisted by looking at these procedure rules, because as my Lord says, there will be some situations where the High Court is given statutory jurisdiction, appellate jurisdiction, and then this is the procedure you use.
That is correct.
There will be other cases, obviously, where the Court of Appeal has statutory appellate jurisdiction, and I would imagine that there are civil procedure rules dealing with those appeals as well.
Indeed, so please, my lord. Those are found at Part 64 of the Civil Proceedings Rules, where the Court of Appeal gets its procedural grant to deal with appeals.
So the picture in relation to both the High Court and the Court of Appeal seems basically to be the same.
That is correct, my lord.
There are procedure rules dealing with appeals to both of them. There is an absence of express statutory appellate jurisdiction in relation to the licensing authority.
That's correct, my lord.
And so isn't that the background against which we have to construe Section 88M9?
Indeed, so please, my lord. So that's what we say, please, my lord, that it is against that background that we now look at Section 88M9 to determine when this right of appeal is given to which one of these courts, whether it be the High Court or the Court of Appeal, the legislator is intending to hand that appellate jurisdiction.
And can I be clear? At one point you said that potentially both can have jurisdiction, but then I think in answer to my lady, you were saying your argument is actually going to be it has to be one, and that one is the High Court. Is that right?
That one is the High Court. That's correct, please, my lord.
And I just wanted to check that you accept that it has to be one or the other. It can't be both.
Indeed, so please, my lord.
Right.
Because the courts generally interpret legislation away from concurrent jurisdiction. We accept that it is either the High Court or the Court of Appeal. And that determination will be made upon a proper construction of Section 88M9. And of course, we say that at paragraph 22 of the case for the respondents, they accept in principle that both the High Court and the Court of Appeal can deal with appeals under Section 88M9. So they take the same approach, essentially, that we are taking this morning, which is that when you look at it, because both courts suffer from a lack of express grant, both courts have procedural rules that guide you in the direction of saying that they can hear appeals from inferior courts. Both courts potentially can be a court of competent jurisdiction, having regard to the definition of a court of competent jurisdiction. The question then really lies in a proper construction of Section 88M9 to determine, well, which court?
Can I check this? So on your submission, is it Section 88M9 which actually confers the appellate jurisdiction?
Indeed, so, Miller. So Section 88M9 confers the appellate jurisdiction.
So you're going to tell us why it's the High Court?
Indeed, I'm going to proceed now to say, well, why it's the High Court? Because we are at a point where we can choose either court. So which one is it? Now, I just want to make the point before going into the construction of the legislation that generally, and it may work for the High Court as well, but we've put three pieces of legislation before the board where the legislature has generally conferred appellate jurisdiction on the Court of Appeal by using express language. So we're talking about the Representation of the People Act, the Arbitration Act, the Town and Country Act. When they're moving from an inferior tribunal up to the Court of Appeal, they've generally said so expressly.
Well, you're saying there'd be similar examples you could give us, if you had time, of when there's an appeal to the High Court.
Yes, please, Miller.
So again,
it's substantially the same position. Correct. If I may, my lords and my ladies. So, perhaps the most important insight into Parliament's intention is the formulation of words that it uses in the creation of the right of appeal under Section 88M9 when compared with the formulation it uses in the creation of the right of appeal in Section 88H, which, like Section 88M9, is to be found under Part 6A of the Amendment Act. So, my lords and my ladies,
Where is that?
At electronic bundle. I'm looking for, if I may, my lords and my ladies, I'm looking for electronic bundle. At the electronic bundle 835, my lord, you will find 88H. And at electronic bundle 837, you will find 88M, the start of 88M, and 88M9 will be found at 839.
That's an appeal from a court.
Yes, please, my lord. 88H?
Yes.
Yes, please, my lord.
So who is that court then?
That would either be the Magistrates' Court or the High Court. So what we say on this point, please, my lord and my ladies, that the starting point to construction.
So I'm sorry, I'm being a bit slow here. Section 88H is creating a right of appeal, but from an order of a court.
Yes, please, my lord.
So the order of the court against which you can appeal under Section 88H, which court is that?
It could be the magistrate's court or the High Court.
Right.
Well, that suggests that the appeal is to the Court of Appeal, presumably.
Correct.
Because an appeal against conviction would be...
It would be an appeal against conviction. Correct, my lord. So that is why we say it is important to start the construction issue by looking at the legislation intrinsically. We look in the legislation to determine what could they have meant. So in 88H, what the Parliament did there, they created a right of appeal, and they said, may appeal against the order in the same manner as against a conviction.
It's a very roundabout way of saying it if they mean the Court of Appeal.
That is fair, my lord. It is a roundabout way, but it is very clear. When one understands the operation of law, it becomes very clear that this is the Court of Appeal. It's a conviction either entered in the summary court or in the High Court, and it's the Court of Appeal. However, when it comes to Section 88M9, it says, appeal to a court of competent jurisdiction against the decision, against that decision. We submit, my lords and my lady, that the
They
form...
can use the conviction language because it's not an appeal from a court.
But what we are submitting, my lord, is that even if it were a decision of the licensing authority, the same formulation of words could have been used. So they could say, as against a conviction, or they could say in the same manner, they could say in the same manner as against a conviction, in the same manner as against a conviction in the summary court or High Court.
Well, they could just have said to the High Court or the Court of Appeal, and it would have made it a lot easier.
I agree with you entirely, my lord. But what we say is that when we compare, and this is where we start intrinsically. When we look at the manner in which the rights of appeal were created in two sections which are under the same part of the Amendment Act, we see a difference in the way Parliament has expressed itself. We see a difference in the choice of language used by Parliament. One tells us very clearly that this is the Court of Appeal. And we say that if Parliament intended Section 88M9 to give appellate jurisdiction to the Court of Appeal, Parliament would have used the same formulation of words it used 3 sections up. It was open to them to simply repeat those words. But they went for an entirely different formulation of words. And it is on that basis, please, my lord, that we say, my lords and my lady, that we say Parliament must have intended something different.
As Lord Hamlin was putting to you, I mean, the analogy doesn't work. It's not, or at any rate, it's not a perfect analogy because the licensing authority doesn't operate like a court issuing convictions from which one expects there to be an appeal to the Court of Appeal. It's a different beast than the courts.
They would have to say something different.
Yes, please, my lord.
Whichever way they wanted to go, you couldn't draft it the same way.
Yes, please, my lord. But what we say is that the formulation of words that was used could easily be tweaked to get to the point of the Court of Appeal. They could say in the same manner as a conviction in the High Court or summary court.
Well, that's making it even more convoluted.
Right? But what we say is that that will get you to the Court of Appeal. The formulation that they use in 88M9 is so starkly different that one has to assume that Parliament meant something different.
But you don't if the analogy is an imperfect one. And if it's exactly the same situation and Parliament had used one form of words in one case and a different form of words in another. I perfectly see the logic of your argument, but I think what we're putting to you is the argument doesn't work because the basic situations are different in the two cases, and so
it has to use a different form of words, whichever way it wants the appeal to go, because it doesn't. It can't say from a court.
Yes, please, my lord. But we say by expressing itself in the manner that it has, a court of competent jurisdiction, it is clearly suggesting something else, not the Court of Appeal. That is our submission, please, my lords and my lady.
Okay.
Because a conviction, an appeal from a conviction would have to go to the Court of Appeal.
Indeed, so please, my lady.
So if you want to analogize with something that goes to the Court of Appeal, then an appeal from a conviction is a good way to do that, as they've done in 88H.
Yes, please, my lady. My lady, if I may have a...
Can you help me? You began this part of your submission by taking us to section 88H, and I'm not sure that I understand it. It says a person who, by virtue of an order of a court under section 88F, is disqualified from holding or obtaining a driving permit may appeal against the order in the same manner as against the conviction. So, a person is convicted of, if they're found to have committed an offence, is this dealing with some form? I'm not sure what it's dealing with. Is it some form of disqualification order in the absence of a conviction?
My lord, what happens is that the court can impose a disqualification order as part of the sentence when you are convicted. So there will be a disqualification order as part of it for those offenses. So the court can impose a disqualification order under 88H if you are convicted of an offense under 88F. So there is a disqualification order involved.
What is an offence under section 70 or 71A?
Those offences...
What kind of offence are we talking about?
Actually, they'd be convicted for the offence under section 72 because the offence is not proven under section 70 or 71A. So
Oh, right.
88F is a substituting. So what is the offence under section 72?
My lady, if I may have the opportunity. It's careless driving, and driving without due care and attention. So a disqualification order might follow from such a conviction.
It's still going to be a conviction. I mean, section 88F is saying you can substitute another criminal charge and try on that other charge.
Yes, please, my lord.
But so is 88H saying that even if you don't appeal against the conviction as such, you can appeal against the disqualification, and that is treated as if you had appealed against the conviction?
Against the conviction.
But if you succeed in that appeal, the disqualification will be set aside, but the conviction will stand? Is that how it would work?
My lady, if I may just have the opportunity to look at it.
Yes, is that all this is? It's just allowing an appeal against sentence, effectively.
A particular dimension of sentence. Yeah, a particular dimension of sentence.
Yes, I don't think it's to be read like that, my lady.
No. Oh, okay.
So,
Well, how is it to be read?
88H. Right. So, as I said, please, my lords and my lady, what happens here is that part of the sentence that the court may give is a disqualification order under 88H. And you are to appeal that order, if you wish to appeal that order, in the same manner as you would appeal a conviction.
Right.
Yeah.
Right? And that tells you, you go to the Court of Appeal. right? So it's the disqualification order that
Yes,
you
but
appeal.
if you succeed in your appeal, is the result that the conviction stands, because you haven't appealed against that, but the disqualification order is set aside?
My lady, if I may have an
That must be
opportunity.
right, mustn't
It must be right if you...
If you haven't appealed the
Conviction, then it doesn't cost you
This will
conviction.
arise in the context of a conviction.
Yeah.
Yes, please. Nick.
Add on to a conviction.
Yeah.
Correct. It is part of the order associated with the conviction.
Whereas if you appeal the conviction and succeed, then of course the disqualification order would
Fall
Yeah.
because it is part of the order on
because
sentence.
it's reliant on the conviction.
So the provisions under 88M effectively are providing an alternative route, or alternative procedure under which may end in a disqualification order being made.
Yes, please, my lord. My lord, what happened under the 2017 Motor Vehicle and Road Traffic Amendment is that there was an introduction of an entirely new regime.
Yep.
So this regime involved a demerit point system. So those sections 88H would have always existed under the old legislation, right? Where you go to the magistrate's court, or if it's careless driving in this case, you could go to it could be on an indictment before the High Court, and you end up being convicted, and your appeal would go to the Court of Appeal by virtue of either the Summary Courts Act or the Supreme Court of Judicature Act.
Yep.
Under this licensing system, you don't get a conviction, is that right?
No, please, my lord.
You just get disqualified.
You just get disqualified.
It's a license.
Well, if you rack up a certain number of points.
Correct, my lady.
Yes.
So if you rack up 10 points, you get disqualified.
Yeah, but there's no criminal conviction.
There's no criminal. The intent of the legislature was to remove the criminal element of traffic offenses and introduce violations. And once you rack up a number of points, my lords and my lady, you could end up being disqualified. And once you are disqualified, 88M9 gives you a right of appeal from the decision of the inferior tribunal, that being the licensing authority. We say that the court of competent jurisdiction to handle this inferior tribunal is the High Court on appeal. And we say that, and my lords and my lady have already suggested there.
If you wanted, suppose you've got 6 demerits, and then you're caught, or 4 demerits, and then you're caught speeding or parking wrongly or whatever, and you want to contest that, say I wasn't driving or I wasn't speeding, that presumably all takes place before the licensing authority, doesn't
No,
it?
please, ma'am. That takes place. So let me be clear on that. If you are contesting a ticket, you take that to the magistrate's court.
So the licensing authority, does it have any adjudicative function? Is it ever called upon to decide?
Well, it is making a decision on disqualification.
Does it have power not to disqualify if it's sort of persuaded that you were...
Well,
Rushing to a hospital.
Yeah, exactly, something like that.
it has a limited power not to disqualify once you are able to show cause. Because the section itself, 88, requires
It's hard to see how you could appeal the decision. If it's just a mechanical thing, you've clocked up the right number of points. And unless they can't add up or something, what are you going to appeal against?
Yes, please, my lord. But the section says it gives the person an opportunity to show cause.
Yes, but it looks as though it must be to do with arithmetic. I mean, looking at under subsection 1, were
Is that subsection 2, my lord?
88, well, I was looking at the provisions in turn. Subsection 1, where a newly licensed driver accumulates 7 or more points, the licensing authority shall disqualify. 2, where a person who holds a driving permit for more than 12 months accumulates X points, the licensing authority shall disqualify. And then in subsection 3, it opens up the a room for assessment, but you have to give the person notice. The licensing authority shall, before disqualifying, give the person notice and specify a date on which the suspension shall be made, and call upon the person to show cause why he should not be disqualified. But what's the content of that? Is it just to say, well, you've made I haven't actually accumulated as many points as you think I have?
Well, my lords,
or I hadn't had a permit for more than 12 months or something,
yes.
Something like that. You make a
Or
mistake like
could
that.
you say, I have to take my child to kidney dialysis every week, and the only way I can get there is to drive, and this will cause me terrible hardship? Is that an argument you can make?
my lords and my lady, presumably you can make that argument before the licensing authority. I can tell you what has been happening in practice.
Yes.
In practice, the licensing authority is not taking on board any of those causes.
Okay.
They are simply operating.
Before it says it refers to facts in mitigation.
It's a strange, because facts in mitigation would arise after a certain point.
Yeah.
So that if you are asked to show cause, it suggests to me that the licensing authority is able to exercise a discretion here and to determine that you have shown sufficient cause, and therefore they will not disqualify you. So in that regard, it operates as an adjudicative body. The legislation anticipates that it will do that, right? Practically, however, this is what we have been experiencing, is that they have been disqualifying you, and essentially you are then moved to your right of appeal.
I can't see how you could ever in practice appeal, though, against a decision not to, as it were, grant mercy in the particular circumstances.
Well, my lord, perhaps what you would be doing is doing exactly what you did before the licensing authority, which is to say, these are the reasons why you would be essentially showing your cause there. These are the reasons why you should not suspend or disqualify my license, because, as my lady pointed out, I have a sick child. I have a child who needs dialysis, and I'm rushing. I was rushing on that occasion to the hospital. I racked up.
No, my example is rather different. Someone who really is very dependent on using the car, and so would suffer considerable hardship. They may say, yes, I was speeding, I have no excuse, but please don't disqualify me because my life will be extremely hard.
And I take my lady's example because that's precisely what happened in this case, not the dialysis issue, but what happened in the case of Zachary De Silva is that he appealed to the court on that very basis. I am a driver. He was a driver for one of the companies, for a company in Trinidad and Tobago, and he was saying, if you take away my license, you take away my job, because my job is I'm a driver.
But presumably, in principle, you could try to deploy both arguments in mitigation. You could say, I was rushing my wife to the hospital, she was about to give birth, that's why I got the points, please be merciful. Or I have to take my child to dialysis every week, please don't disqualify me because that'll stop me doing that. You could deploy either of those sorts of arguments, one might have thought. Can I just check, if you do, and you're unsuccessful before the licensing authority, is the appeal under subsection 9, presumably that just gives whichever is the appellate court the right to look at the thing afresh and decide whether it would mitigate.
Certainly, please, my lord. It is a review power that is given under 88M9.
Well, you say a review power, isn't it?
It's a rehearing, essentially. Sorry, a rehearing.
Yes, that's what I was asking. Yes.
And would that be an oral hearing? I'm assuming before the licensing authority you just send in, or are there hearings before the licensing authority?
What you do in practice is that you would send in a letter, indicating this is what has happened to me. These are my reasons. This is my show cause. So after you receive the notice, you send a letter showing why.
And then they send you a letter saying, we've read your letter, but we're disqualified.
That's exactly what happens, my lord, in practice. They've read the letter, here's your notice of disqualification. And then you
But
go...
there's no hearing, it's all just done on the paper.
It's essentially all on the papers.
But presumably, when you appeal to whichever court is the court of it, which hears the appeal, that will be an oral hearing.
That would include an oral hearing, please.
So you do get the opportunity to go before a judge and explain more fully than
Yes, please, my lord.
Just on paper.
Yes, please, my lord. So what you would do, you would file your notice of appeal. Your notice would be supported by your grounds, and then it would proceed through a normal case. The court would give directions as to whether or not it would hear oral evidence, affidavit, or whether you file an affidavit. Whatever it is, it turns into a trial procedure at that point.
Why is Mr. De Silva concerned whether it's the High Court or the Court of Appeal?
Mr. De Silva is concerned about the High Court or the Court of Appeal because there's a substantial difference in cost associated with going either to the High Court or to the Court of Appeal of Trinidad.
And is that just in terms of the fees that are paid to it? Where does the cost?
It's fees. It also includes bundles, getting the matter together, because if you go before the Court of Appeal, you're going before 3 judges. So getting things together for a Court of Appeal hearing are substantially different from getting things together for a High Court hearing. Now, the Court of Appeal, and I close the point that I was making, and I take my lords and my ladies' position on the point, but the point that I was making is that we need to look intrinsically at the legislation and make a comparison in the manner in which the Parliament approached giving or creating this right of appeal and the language associated with both rights. So I'm going to close that point, and I'm going to move on now to discussing the issues that troubled the Court of Appeal. Now, as my lord and my ladies will know, I appeared in the Court of Appeal for Mr. De Silva, and I appeared at the hearing. And it is my respectful view that the issue that troubled the court the most, and which at that time we were not able to fully answer the court, the issue that troubled the court the most, and they questioned vociferously on that, particularly the judge that that wrote the judgment on behalf of the court, Justice of Appeal Buddha Singh, the issue that troubled him the most, and he spent a considerable time as well in his judgment discussing that, is the bifurcation issue. And he gave the example between paragraphs 27 to 30, but in particular 29 and 30 of the judgment, which can be found at electronic bundle 268 to 269. And I'm not going to read what that judgment says, but I'm going to see if you will, what he was getting at. The judge's fear on that occasion was that the demerit points associated with a ticket could be used by the licensing authority in determining a disqualification, while at the same time that ticket has been challenged. And a challenge to a ticket, a challenge to a conviction, so you get a ticket. Let me break this down as simple as I can. You get a ticket. That ticket now has demerit points associated with it, 4 demerit points. You challenge that ticket, and therefore you have to go to the magistrate's court to deal with that challenge. but that ticket has demerit points, 4 demerit points associated with it. So it goes to your demerit points. You are convicted at the magistrate's court, and the points stand. You then challenge that conviction that the magistrate has entered, and that goes to the Court of Appeal. But then you've racked up sufficient points that the licensing authority can disqualify your license. So here you have a situation where you are before the Court of Appeal dealing with a ticket where the points gained from that ticket have now caused your disqualification by the licensing authority. The Court of Appeal upholds your appeal, and therefore those 4 points, and this is this fact scenario that my lord in the Court of Appeal was working with. The Court of Appeal upholds your appeal. Those 4 points ought not to have been associated with your disqualification. You appeal the disqualification of your license to the High Court. The High Court dismisses your appeal from disqualification. They dismiss your appeal from disqualification. But then the Court of Appeal has upheld your appeal, and those 4 points should never have been part of the number of demerit points that allowed.
He was concerned you could end up with an unchallengeable disqualification, even though the basis for it had been cut away because one of the tickets that counted to disqualification has been held to be unlawful.
Indeed, so please, my lord. That is essentially it, please, my lord. And we say that the legislature considered that possibility, not that they considered, they dealt with that in section 88K of the legislation. K2, it says, where a person appeals against conviction under subsection 1, no demerit points shall be recorded against the driving permit record of the person unless the conviction is confirmed on appeal. And it could be found at page 836 of the electronic bundle.
But does it say that a disqualification order that's been made automatically falls away, or you would still have to appeal the disqualification order?
Well, you will still have to appeal the disqualification order, but what this is saying is that no points associated with that ticket, once it is on appeal, can be used as part of your disqualification order.
So you can't clock up the right number of points until the appeal has been.
So there is no bifurcation. There is no you being in different courts at the same time, and the points associated with a ticket is going here, there, and everywhere. It's as simple as that. And we say, please, my lords and my lady, that the court never took cognizance.
You didn't point it out to the court.
Well, my lord. That is correct.
So so the scenario that the Court of Appeal envisages of the High Court upholding the disqualification order, even though it relies on 4 points for a conviction which has now been set aside, that oughtn't to happen because something would have gone very wrong if it does happen, and if something's going to go very wrong, it could equally go wrong between 2 benches of the Court of Appeal as between a bench of the Court of Appeal and the High Court. Is that?
Yes, please, my lady. So it sweeps aside, we say, the principal fare of the Court of Appeal in relation to that issue. And we say that that was the issue that troubled the court the most. So the court never took cognizance of the language difference between 88H and 88M. The court also, and I take my lord's point, and we didn't point the court to 88K of the legislation that deals with the issue that troubled him the most.
I mean, There is still a little bit of an oddity with section 88K2, because that's where a person appeals against conviction under subsection 1. But I thought under section 88F,
That's a different scenario, though, isn't it?
a disqualification could be imposed, and then you could have an appeal against the disqualification under section 88H, even though you're not challenging the conviction.
That's a different form of disqualification. Here you're talking about an appeal against a ticket that counts towards points disqualification.
Yes.
Right.
Yeah. You could be,
So these are for tickets that count towards points disqualification. So it can't, we say simply, yes.
I see.
But if you appeal against the disqualification order and you succeed, but you don't appeal against all the demerits, you've still got that triggering number of demerits on your license. If you then err again, presumably they can still rely on those 4 points as towards the number of points that they would need to try and disqualify you again. I don't know how many points.
Well, it would be 10 in the first instance.
Yes, but how many points do you get for each infraction?
No, they vary.
They vary.
They vary depending on the infraction.
Okay.
But certainly, my lady, in answer to your question, once you have appealed against the conviction, and there are points associated with that, yes.
Then, if you win, then the points are set aside.
Yes, and even before you win, my lady, the points don't count yet until the appeal is fully ventilated and a decision is made.
But if you don't appeal against the conviction, but you successfully appeal against the disqualification, then the points stay. You still have the 20 points on your license or whatever it is, because the convictions have not been set aside. It's just the disqualification order has been.
My lady, I don't see how that arises. I apologize, but I don't see how.
There's no convictions under this system, it's just points. Is that
Yes, please.
There's no
It's only
convictions.
points. Right? The 88F deals with another situation.
Yes, all right. Forgetting, yes, not a conviction, but you still have the points.
could I ask Mr. Rodriguez, you've taken us to 88K2 as an answer to the Court of Appeal's concern. Now, 88K2 is dealing with the situation where somebody appeals against a conviction under 88K1, which is conviction of various types of offence that carry demerit points. Now, it may be the Court of Appeal were more concerned about the situation in 88K3, where a fixed penalty notice is issued for a traffic violation that carries demerit points. Now, is there a similar suspension of demerit points if a person contests the fixed penalty?
If I may, my lord. Which sections is it?
Because that's what we're actually concerned with, isn't it?
Yeah, my lord, there is a section in here that also indicates that once you contest a fixed penalty notice, the points equally don't count until you ventilated the appeal. And
Now, you're telling us that, but where do we find that in the legislation?
my lord, we're just looking at it here, but we know that it is there. If we could get the opportunity to point it out to you once we
Because you see, his concern is about tickets.
Which is actually what we're concerned with here, because
Yeah.
it's what Mr. De Silva got tickets, didn't he?
Yes, please, my lord.
Going through a red light or whatever, you get a ticket, and then it clocks up 3 of those, and the licensing authority, without any conviction for any criminal offence, your licence is disqualified for 6 months.
So,
Yes, please.
So, I mean, those tickets we're talking about are, I think, what's meant a shorthand way of referring to fixed penalty notices issued under Section 81.
Indeed, so, my lord.
Yeah. In which case it's subsection 3 where it's more relevant than subsection 2, I think.
My lord, if I may just continue, and when we get to the point, we would indicate to the court which section it is. So I'm going to press on and indicate that heavy weather has been made of the general scheme of the legislation, and the historical context are showing a general preference for conferring jurisdiction for appeals on the Court of Appeal.
I wonder if I'm sorry to interrupt you, but I just wonder if the answer may be, just looking at subsection 3, that it's saying that where the notice is issued and either the penalty is paid or the time for payment has expired, but a notice to contest the penalty hasn't been filed, then the number of demerit points shall be recorded. So so the answer seems to be that it follows from that if you did contest the notice within the specified time,
it will not be added to your points until you have fully dealt with it.
Yeah. Yes, so there is an answer to...
Yes, please, my lord. 88, that would be 88K, 3, A and B.
Yeah.
My lord, I apologize. I should have seen it. It's in the very same section that I had mentioned.
Perhaps I should have seen it faster.
But where is the provision about notice to contest the fixed penalty?
Those are earlier in the amendment, please, where you deal with notice to contest.
I'm sorry, I missed that. What did you...
I said they are earlier on in the amendment where they have set out the provisions of contesting a fixed penalty notice.
Can you help us with...
Yes, please, my lord. I'm feverishly getting to that point.
Well, while that's being looked up, could I just ask you this, which is a point, I think, on the scheme of this new part of the Act, and it's going back to the right of appeal under Section 88H. As I understand it, where one's been convicted under Section 88F and a disqualification order has been made, you have the choice not to challenge the conviction, but just to challenge the disqualification order. Is that right? It seems to be Section 88H seems to be contemplating that you can have an appeal
Against the disqualification
order
without appealing the conviction.
Yes.
Yes, please, my lord, because they say in the same manner as against the conviction. So it's sort of contemplated.
Just thinking about the scheme of the legislation, that seems to be a clear indication from Parliament that if you're just contesting a disqualification order, I appreciate one that's been imposed in a particular context, that contestation is properly a matter for the Court of Appeal.
Yes, please, my lord. I would say it.
So if Parliament has clearly made that choice, I appreciate you say they didn't use the same language in Section 88M9, but if one's looking at it more schematically, one can see that Parliament thinks a challenge to a disqualification order, where that's the only issue, should go to the Court of Appeal in that context. Why wouldn't one draw the conclusion that they think that that's the appropriate place for that sort of issue to be dealt with, i.e. the Court of Appeal under Section 88M9?
Well, my lord, the first thing we say to that is that the appeal there arises because it is an appeal from an order of the magistrate's court or the high court. So that the appeal really, or the jurisdiction of the Court of Appeal there, really comes from either the Summary Court, the Summary Courts Act, or the Supreme Court of Judicature Act.
And you say if it wasn't to the Court of Appeal, the High Court could be in the position of having to hear an appeal from itself?
Yes, please, my lord.
Okay.
I see the section 85, which is
Yes, please, my lord. I was about to point you to
828, deals with contesting a fixed penalty notice, and the effect of filing a notice to contest under section 87 is that the case is then listed for trial in court.
Indeed, so, my lord.
So if you contest the fixed penalty notice, then you then go to trial.
You go
on
to
question
trial.
whether or not you jump the lights or whatever it is.
Correct, and it would be a trial in the magistrate's court. So again, please, my lord, much has been said about the general scheme of the legislation and the historical context in which it has been built as preferring jurisdiction for appeals on the Court of Appeal. In answer to that, we say the following. If this is the case, if the legislature had a preference for using the Court of Appeal, then the legislature well understood the formulation of words that would allow it to confer on the Court of Appeal clearly.
Yeah.
So,
I'm sorry to interrupt you, but it's just while it's following this train of thought. So if one goes to the reasoning of the Court of Appeal in paragraph 29, whatever page that's, I'm afraid I don't know what, electronic page 268, where it talks about the bifurcated process. There's, for example, if Mr. De Silva's submission is accepted, an appeal from a magistrate in respect of the issue of a ticket would lie to the Court of Appeal. Now, what he's meaning there, I think, is the appeal wouldn't be in respect of the issue of a ticket. The appeal would be
in respect of a
guilty
conviction
of the offence,
correct,
in respect of which the
ticket was associated.
An appeal against conviction.
Conviction.
So an appeal against conviction.
Yes, except it's not a conviction, you know.
Sorry?
It's not a conviction because it's not a criminal offence when we. Isn't that?
No, once you challenge
Once you challenge it.
once you challenge the ticket,
Sorry.
The same as in the UK.
Yes.
You're going to.
it would go to the magistrate's court, a trial will ensue, and the magistrate would enter a conviction at the end of the trial.
Yes. So an appeal from the magistrate against conviction would lie to the Court of Appeal. But a disqualification by the authority utilising that same ticket, but that couldn't happen
That's the point, my
because
lord.
of
88K.
88K3.
Correct, my lord. So we say that it does not arise.
Yeah, and if we, and then we returns to this topic in paragraph 30 on page 270. It says the High Court if an appeal against the imposition of the demerits points, the disqualification resulting from demerit points, lies to the High Court. The High Court could potentially dismiss the appeal under disqualification from driving resulting from the application of demerit points. And then the rest of that sentence is mistaken.
Indeed, my lord.
Because the Court of Appeal wouldn't be concerned with the ticket at all. The Court of Appeal would only be concerned with
the conviction.
With the conviction and any
Yes.
sentence following on from the conviction.
From the conviction.
And if that whole matter were under appeal, there wouldn't be demerit points
associated with that. Yes, please, my Lord. My Lord is entirely correct now.
But what happens if you appeal against the ticket to the magistrate's court and you lose and you have the conviction then, what happens to the demerit points?
Well, then the demerit points are entered.
Yeah.
So they're properly entered now because you haven't appealed it. 88K does not kick in. You get your demerit points. It is then associated with your license. And then if you attract as many demerit points as the legislative scheme requires, you can then be disqualified. So disqualification can then come from the licensing authority. And then you have a right of appeal under 88M9 from that disqualification. So because you've racked up 10 points or 14 points or whatever you have there, you then appeal to the High Court from the decision of the inferior licensing authority, and the High Court, a trial ensues in the High Court. You file your notice of appeal supported by your statement of case in respect of Part 60, and the court gives directions to the licensing authority, and from there you move into a trial process. But the court there will definitely be dealing as well with your show cause issues.
Yeah.
And we say that the Court of Appeal is not the place for that. Where 3 judges have to hear these routine, everyday matters. 3 of the country's most senior judges have to sit on these matters.
Well, Mr. Justice Seepersad seemed to think the High Court was too busy to deal with these matters.
Well,
Didn't he say something like that?
but he did, in fact, make those suggestions that the High Court, which has several more judges than the Court of Appeal available to it, was too busy. I don't know if he was there suggesting something about the Court of Appeal's workload, but certainly.
I think it's paragraph 17, Justice Seepersad's judgment that my Lord had in mind.
No.
I suppose one could say the Court of Appeal seemed relaxed about it.
Indeed, my Lord. But I would imagine that the workload of the Court of Appeal is significant, especially when you have to bring together 3 judges to hear this type of appeal.
And is there an automatic right of appeal, or do you have to apply?
No leave. It's an automatic right of appeal.
Right, yeah.
Yeah, it's an automatic right of appeal. Right? It's expressed as a right of appeal.
Yeah.
So what we say in respect to the general scheme of the legislature point and the historical context in which it is built, we started off by saying, well, look, if Parliament had this preference for the Court of Appeal, as it is being said, is shown, then Parliament knew quite well how to draft the legislation that would take us to the Court of Appeal, as they did in 88H, as they have done under the Summary Courts Act, as they have done under the Supreme Court of Judicature Act. It's quite easy for Parliament, having this historical context and this general scheme, to draft language that will take us to the Court of Appeal. So we say that the fact that the language has been drafted in this manner should weigh against any idea that the Parliament wanted us to go to the Court of Appeal to deal with these very routine traffic matters.
But if it's not the Court of Appeal, how do you decide whether it's the Magistrates' Court or the High Court?
Well, we say that it definitely cannot be the Magistrates' Court. All courts, all of the 3 courts that have dealt with it, or rather the 2 courts that have dealt with it, have indicated that it's not the Magistrates' Court, because the Magistrates' Court has no appellate jurisdiction. not even from an inferior court. The Magistrates Court is a creature of statute. The Summary Courts Act does not envisage the Magistrates Court to have an appeal jurisdiction. There's nothing there to support an appeal jurisdiction in the Summary Courts Act.
Well, yeah, except I think you told us that your case is that Section 88M9 is itself the provision which confers the appellate jurisdiction.
Indeed, so please, my lord, but the practice in the Magistrates Court has simply never been that a magistrate receives an appeal from an inferior tribunal or from any tribunal. I've never seen an appeal in a Magistrates Court. The Summary Courts Act does not contemplate such a situation. There are no procedures in place for an appeal from a Magistrates Court. We wouldn't know what documents to file.
That was the respondent's case before the judge, was it? That it should go to the Magistrates Court?
No, please, my lord, no.
Well, I thought
The respondent never took that point.
well, the Summary Courts, that's the magistrate.
Yes, please, my lord.
Yes, that's what the respondent saying in paragraph 21, that was their case, but is no longer.
Okay.
Was our case at first instance?
At first instance,
Well, we said it's either the Summary Court or the Court.
or the Court of Appeal. What they said.
Not the High Court.
And you say that this is an appeal because the licensing authority does carry out an adjudicative process under the
Under Section 88, they're carrying out an adjudicative process, 1. 2, it is an appeal because the section itself expresses it to be an appeal.
If there was nothing in the section, there might have been ability to challenge by judicial review the licensing authority decision.
Indeed, so please, my lord. But the section gives the right of appeal, and therefore it would have been an alternative remedy. And the court in the Court of Appeal, Justice of Appeal Suhan, did raise such an issue. Why didn't you go by way of judicial review? And I indicated to the court then that there is a right of appeal under 88M9, and that would constitute an alternative remedy, and I can't go by way of judicial review. I'm before you on 88M9, which provides the right of appeal.
And can I just ask, we're told but in the definition section, section 80, that the word court has the meaning assigned by the Summary Courts Act. What meaning is that?
My lord, importantly, that would be the Summary Courts. However, 80 is found in Part 6 of the legislation, of the Amendment Act. The sections that we are dealing with here are found in Part 6A.
I see.
Which assign no meaning to the word court.
Fine, thank you.
Does the Court of Appeal hear appeals from any comparable bodies, or does it only hear appeals from courts, basically?
Well, we have set in some legislation which reflects the fact that the Court of Appeal does hear some appeals from inferior bodies. There's no doubt about that. They do hear appeals sometimes from inferior bodies. But what we say is that those pieces of legislation have generally expressed, and the seriousness of those pieces of legislation are quite extraordinary when one compares it with the routineness of the licensing authority disqualifying your license after you've racked up a certain amount of demerit points. My lord, we can envisage, and any court can envisage, that there will be numerous appeals of this nature. In fact, that is what is happening. On a practical level, there are numerous appeals of this nature. And they will be all heading to the Court of Appeal, where 3 judges will have to sit and deal with this. And, of course, we express some anxiety about that because litigants going to the Court of Appeal are also expected to pay more in fees with respect to a Court of Appeal hearing versus a High Court hearing. Now, I was going to leave these points here for dealing with the policy issues associated with the legislation. But I might as well express to the court at this point that there are some further issues. You have a license here that could be suspended for approximately 6 months according to the legislation. The practical scenario in Trinidad and Tobago now is that the Court of Appeal will not hear an appeal in 6 months. So that what you are going to have is not just the appeal, but you're going to have a number of applications for stays. Because if you look at Mr. De Silva's case, it resulted in us having to apply for a stay in the Court of Appeal. And if you look at when the matter was heard, it was heard substantially into the period of disqualification. And that's the general position. This might have been one of the best, because it is the first case that came up. So what
you always have to get a stay?
Sorry, my lord?
Won't you always need a stay? I mean, if the licensing authority, or is there an automatic
There's no automatic stay.
No, so, I mean, your disqualification will start right away. If you want to appeal, and you don't want to be off the road, immediately, you'll need a stay from whichever court, won't you?
Yes, please, my lord, you would need a stay, but the possibility of the High Court dealing with it more swiftly is much higher than the Court of Appeal in Trinidad and Tobago.
What happened to Mr. De Silva? Has he done his 6 months, or has he managed to stay on the road all this time?
No, my lord, his 6 months have expired.
There was no stay?
There was a stay in the Court of Appeal. So we did stay in the Court of Appeal, and once the decision was given in the Court of Appeal,
at that point, the disqualification took place?
Yes, please, my lord.
Yeah.
These points about the fees and the difference in the fees, is that a point that was made to the court below?
No, please, my lady. The point wasn't raised in the court below.
Sorry?
The point was not raised in the court below.
I'm just thinking aloud. These are these appeals categorized as civil or criminal?
We file it as a civil appeal.
Yeah, I suppose it's.
And my lord, I'm sorry.
Because the fixed penalty notices are. It's been in this country they've been said to decriminalise these road traffic matters. But always going through my mind is one might have thought if you had a court of appeal which had a criminal division, they might end up in that division. But if you go to the High Court, obviously that's a civil jurisdiction.
Yes, please, Miller. And my lord has hit it on the head. In Trinidad and Tobago, the attempt there was to decriminalize it as well and to turn them into violations. So they are now being treated as civil, right? So that is why you go.
Yes. You're challenging a licensing decision. You're not challenging a conviction associated with a criminal conviction.
Correct, please, my lord.
Yeah. Yeah.
So we say as well, my lords and my ladies, that my friend has expressed that the policy of the 2017 amendment in the case for the respondent think it is at paragraph 22.
So I think it follows from the discussion we've just had that the Court of Appeal's reasoning in paragraphs 31 and 32, which is based on the idea that it would be surprising if jurisdiction in these appeals were given to a civil High Court judge, with the effect of taking away or denying the Court of Appeal a jurisdiction on road traffic matters that it previously exercised. You would respond that there's nothing surprising about a civil court being given responsibility for a civil matter.
Indeed so, Ms. Mayor.
And that this is different in nature from the road traffic appeals that the Court of Appeal was used to dealing with.
Indeed, my lord. Yeah. The convictions that would arise from the magistrate's court. This is a civil matter because it's arising from the decision of the licensing authority on a disqualification point.
And it's just the kind of thing you would say the High Court will be dealing with in terms of judicial review, although not an appeal, all the time.
Indeed so, my
lord.
lord.
Authorities of this kind.
Indeed so, please, my lord. So generally, it would be the High Court on judicial review, except that the legislation gives a right of appeal. The language associated with such an appeal would mirror judicial review language, so that the High Court would be dealing with this all the time.
Yes, but the scope of the appeal obviously wouldn't be, I wouldn't have thought, restricted to questions of reasonableness, propriety of motive and so forth of the licensing authority. Might go to the sort of issues that my lady was putting to you earlier.
And indeed, I understood you to
say yes,
to submit that, because that's what I was putting.
Yes.
So there would be a fact-finding, there would be leading of evidence if matters were contested, and fact-finding.
It would involve a fact-finding mission, but I was just suggesting that in drafting your appeal, if the licensing authority says, I do not consider, so I disqualify you, right? One would put in their notice of appeal that the licensing authority's disqualification was unreasonable, because you've shown cause. You've sent in this document saying that I have to drop my child to school, my child for dialysis, and you've shown cause why you should not be disqualified. And the licensing authority writes back to you, they don't give any reasons, because they don't. That's practically what happens. They don't give any reasons. They just send you your notice of disqualification. You would be saying in your notice of appeal that they failed to give reasons for the disqualification, that the disqualification having regard to the cause that was shown was unreasonable. So the grounds I'm saying would mirror judicial review grounds, as it will, but a trial will ensue with respect to the fact-finding mission as to whether or not they have acted unreasonably, whether or not they have taken into account what you have said in your show cause notice.
I mean, I suppose you might say that if there has to be a trial of fact, for instance, in my latest example, my child needs dialysis every week, that might not be accepted. So who would be the other party? I suppose it would be the licensing authority. And there had to be a trial of that fact before you could get to the question whether
they've acted unreasonably. Yes.
Perhaps you could say, well, if you're going to have trials of fact, that's more naturally something that happens at first instance.
Yes, please, my lord.
But if it's an appeal, I'm not sure. I mean, you wouldn't be trying the facts, would you? Either way, if it's an appeal.
No.
It's not a trial. It's an appeal.
But it is an appeal by way of rehearing, perhaps.
Yes, but I assume that there are rules. We haven't looked at what the High Court rules are.
Well, Part
If it's in
6.
the Court of Appeal, you couldn't admit new evidence unless it could have been put in and before the...
In fact, Part 60 treats such an appeal as an appeal by way of rehearing.
But we're envisaging that the person has received the notice that he's going to be disqualified, and he's written in response saying, A, I was speeding because I was taking my wife to hospital because she was in labor, and B, I'm a taxi driver and my livelihood will be destroyed if you take away my license. And the licensing authority nevertheless disqualify him. And he appeals against that. Now, if on appeal the licensing authority dispute that his wife was in labor at the relevant time, then there will have to be evidence led about that.
Indeed so, my lord.
I would have thought.
That's what I was...
Oh, I see. Well, the High Court rules do say the court may receive further evidence on
Yes.
matters of fact.
And it says at 68, please, my lord, the appeal is by way of rehearing.
Yeah.
That's in the High Court rules.
Yes. And it's not really a sort of, it's not really a fresh evidence situation. It's more
No.
just proving well, the assertions, the mitigation that you were putting before the licensing authority. So, if it goes to the Court of Appeal has to be able to hear evidence.
Have a hearing of evidence.
Do they have similar? Is there similar provision in the Court of Appeal rules that you can hear additional evidence on matters of fact, or are they different?
Do they have a witness box in the Court of Appeal? Yes, I've done it in
Yeah.
as well.
You might have to shift court. So
Yes.
there is a witness.
Yes, on a fresh evidence.
Yes, of course.
I don't know if it's allowed in Marshall, but it comes to Rule 64.17 in
Yes.
page 2092.
2092. So the Court of Appeal does, and it says, the court may receive further evidence on questions of fact either by oral examination in court, by affidavit, or by deposition. Now, we accept that this does give the Court of Appeal the ability procedurally to do it, but we say that this is not usually done in the Court of Appeal. This is done by way of an application, whereas this is the High Court routinely rehears matters.
Yes, I suppose you could say this point lives with the point you were pressing upon us, that one wouldn't necessarily expect matters in relation to disqualification from driving to be diverted to a three-judge court rather than
Yes, please, my lord.
than the High Court.
Yes.
And a single judge hearing, rehearing a simple traffic matter. So, just to get back to that point that we were making in terms of what is said by my friend in the case for the respondent, that the policy of the 2017 scheme is simply to extend to the licensing authority the power to disqualify, which previously was only exercised by the court. We say that that is a limited view of the policy. In fact, the policy is properly expressed, or the extent of the policy is expressed in paragraph 36 of the Court of Appeal's judgment. It went beyond this. The creation of, or the extension to the licensing authority of this adjudicative power was against the backdrop of a broader policy of moving the backlog that existed in the magistrate's court with respect to traffic offenses. So at paragraph 36 of the Court of Appeals judgment, they expressed it. It's at page 274 of the electronic bundle. The court says it is logical to infer from the structure of the legislation that one rationale may have been to ease the workload of the magistrates' court by removing from them the administrative aspects consequent upon a decision that the requisite number of the merit points had been reached. That was quintessentially a major policy issue in the legislation, which was to remove backlog on traffic offenses from the magistrates' court, create a system of demerit points, create a system of violations as opposed to offenses, and let's move some of this over to the licensing authority. Effectively, what then would be a policy of removal of backlog would now cause the Court of Appeal, if it were to receive appeals from the licensing authority, to inherit that backlog. Because here you would have a third layer of appeals going to the Court of Appeal. So the Court of Appeal would be dealing with appeals from the Magistrates' Court, appeals from the High Court, appeals from the Magistrates' Court pursuant to Section 128 of the Summary Courts Act. They will now be dealing with appeals from the High Court pursuant to the Supreme Court of Judicature Act. And the Court of Appeal will now be dealing under Section 88M9 with appeals from the licensing authority. So if part of the policy motive of the Parliament was to take away some of the backlog, we struggle to understand why they would rest some of that backlog now with the Court of Appeal.
Well, you say 36 makes the same mistake, that they're assuming it can only be the Court of Appeal because that's the appropriate...
My Lord, I'm struggling to hear.
In paragraph 36, the Court of Appeal is assuming that an appeal can only be to the Court of Appeal because that was the court that used to deal and does deal with appeals from the magistrates.
Yes.
And you say, well, that is making the same mistake as was pointed out before, that it's treating this kind of a procedure as similar to a criminal conviction in the magistrates.
Indeed, so, my Lord.
It's materially different.
It's materially different. This demerit point system, this new regime, was intended to create an entirely new system. And looking back at what previously occurred under the old system where we had offenses, and where those offenses, if you are convicted or any other thing, you would go up to the Court of Appeal pursuant the Summary Courts Act. Whether it was a conviction or an acquittal, you had the right to go up to the Court of Appeal pursuant to the Summary Courts Act, Section 128. This new regime is drastically different, and the court ought not to have looked backward in making its interpretation of Section 88M9 and treating it as a criminal offense, or suggesting that because it was there previously, and we have to be careful with the way we use the word previously, because there is no previous, really, to this new system. It was there previously by virtue of Section 128 of the Summary Courts Act, not ever in the Motor Vehicle and Road Traffic Act.
And the differences, you say, are that this is now a civil regime, not the criminal regime, and
Indeed,
also that there will have been no previous trial with evidence as there would have been before the magistrates. Is that...
My lady, if you could repeat that.
You say this is a completely different system from the previous system.
Yes.
And I'm just wondering if you could just enumerate what are the key differences which you say make it inappropriate for the Court of Appeal to look backwards, as you say.
Well, the first thing, it is not an offense.
Yeah.
This is not an offense. This is a traffic violation, so it is treated as a decriminalized or criminal situation. The second thing is the procedure.
In what sense?
the procedure under a criminal offense, when it goes up to the Court of Appeal, the Court of Appeal, it would be unusual for the Court of Appeal to receive new evidence.
But that starts from the fact that you've had a trial for a criminal offence in
Correct,
the
my
magistrate's
lord.
court,
Correct.
whereas here you've just written in a letter and got a standard form letter
Correct.
back.
So this is really your first form of a trial procedure when you come before the court. You don't have any trial process taking place before the licensing authority. Your first shot at a trial is when you come before the court. And we say that this trial procedure ought to take place in the High Court.
And that's it. That's your only shot.
That is your only shot, please, my lord. Rather than, in other words, the decision of the High Court judge who has now heard the trial of your appeal from the licensing committee authority, the decision of the High Court judge is treated as a decision that is final. But my lord would appreciate that such a circumstance is not unusual, where a High Court judge is given the right to decide a case finally and conclusively. And the legislature has sometimes given that right to the High Court judge.
Well, it's going to be primarily a factual dispute, isn't it?
Correct, please, my lord. And that is precisely why.
Rather than a point of law arising.
Correct, my lady, sorry. That is precisely why finality resides in the High Court judge there, because it's a question of facts. And it's
Can I ask you about something a bit different? In paragraph 35 of the Court of Appeal judgment, on page 273, they discuss the jurisdiction of the Court of Appeal, and I'd just like to be sure I've understood this correctly. They say that it's a Superior Court of Record. They refer to Section 35 of the Supreme Court of Judicature Act, which we have on page 899, which tells us that subject to the Constitution, to the provisions of this Act, and to the rules of court, the Court of Appeal shall have all the jurisdiction and powers formally vested in the former Supreme Court in the exercise of its appellate jurisdiction under the Judicature Ordinance. And then we find the Judicature Ordinance itself, or the relevant provision, on page 1016, I think, which section 20, this is dealing with the jurisdiction of the Supreme Court of Trinidad and Tobago, and says there shall be vested in the court all such jurisdiction as is vested in or exercisable by the High Court of Justice in England. Is there anything? It rather looks from that as though the it looks from that as though the Court of Appeal's jurisdiction isn't confined to matters specifically given to it by statute. Other than its jurisdiction being of an appellate nature, which we get from the first of the provisions we just looked at.
Lord, if I may just have a minute to observe you.
I'm not sure it is referring, though, to that one on 1016, is it?
Oh, maybe it's not.
Because according to the Court of Appeal judgment on bundle page 258, paragraph 12, the section is referring to the 1950 Judicatory Ordinance.
1950 ordinance.
Section 32.
Section 32, and then that has a whole string of
Yes, please.
powers, appellate powers, which actually is quite specific, and it doesn't
Include.
include this. But
My Lord, I think the reference under 20 is actually to the Supreme Court as it then was, which is the High Court now. So that is the Supreme Court as it was. So this 20 deals with what is essentially the High Court, and the reference to the jurisdiction of the Supreme Court of Appeal
Yes.
starts at 32.
Yes, my Lord is quite right. And subsection 1 is jurisdiction to hear appeals from judgments by or orders by a single judge, and then 2 lists specific statutory jurisdictions.
Yes, please, Madam. So we did set out all of that in our submissions, please,
Yeah.
my Lord.
Yeah.
But what is very important about that delineated list under 32 is P, paragraph P, which says, all or any other matters in which by any ordinance, whether passed before or after the commencement of this ordinance, a right of appeal to the full court is or shall be expressly given.
And as I understand your point right at the beginning was that you accept that regardless of whether it's the High Court or the Court of Appeal, they both would need to rely on section 88M9 actually falling within that little p.
Yes, please, Milady.
Section 30.
I'm just pointing out that to show,
well, that's only P only applies to the Court of Appeal.
correct, that it
So
applies.
what would it be for the High Court? Nothing, presumably, because its powers are not the jurisdiction
Limited,
is not encapsulated in statute.
Correct.
Yeah.
It's beyond statute.
Sorry, but appellate jurisdictions usually are encapsulated.
Indeed, so, my Lord.
Don't they?
So there is a distinction between the High Court's original jurisdiction and the inherent jurisdiction that it has on the original level versus the appellate level, where it is encapsulated generally by statute. So I accept that. But I just make this point to say that the legislature went out of its way to say for the Court of Appeal that it is only where it is expressly given.
Right. But I'd have thought that that's actually expressing a general principle. Appellate jurisdictions in law only exist where they're given by statute.
Yes, please, my Lord.
And that's true both for the Court of Appeal and the High Court. It's true that Q says it in terms for the Court of Appeal, but the same would be true by general principle for the High Court.
I accept that, please, my Lord.
Because it's an appellate jurisdiction.
Because it is an appellate jurisdiction, it is generally, if not always, conferred by statute. There's no inherent jurisdiction on the appellate level. It's on the original level for the High Court.
I mean, that just takes us back to the start of the debate.
But that's what we said at this time, that we're not...
High Court or Court of Appeal.
Correct. We are here in an exercise where it can be either or, really, but the which it is depends on a question of interpretation. It depends on a question of looking at what the legislature's intent was when they drafted this, when you look at 88H, 88M, when you consider the policy issues, when you consider all of these things, when we consider the procedures set out to support the right of appeal for both the Court of Appeal and the High Court. When you consider the procedures, one will inevitably come back to the High Court as being the court that is better suited here. And the intent of the legislature here, having regard to the fact that this appeal arises from an inferior court, the licensing authority, the appeal is likely to be a rehearing because of the very nature of how it goes. It's a rehearing. These are all matters that weigh in favor of saying, look, the Parliament intended for this court of competent jurisdiction to be the High Court because of the very nature of what is involved here. And because they've traditionally, as my friend says, conferred appellate jurisdiction on the Court of Appeal, but they've done so in a manner that is pellucid. Why here have they put it like this?
Well, I think pellucid is putting it a bit.
You told us that there are other examples of the High Court being given a final appellate jurisdiction. Can you point us to any?
The High Court being given final appellate jurisdiction.
I noted your...
Yes, please, my Lord. If I may be given the opportunity in response to deal with that, we will just look at it and we'll point out. But I'm certain there are pieces of legislation that give the High Court final appellate authority.
Now, I appreciate we have engaged you in debate most of the time you've been on your feet, but I hope it's been productive. We're going to have to let Mr. Benton speak fairly soon. So is there much more you have to add?
No, please, my Lord. I was at an end. I was at an end, please, my Lord. So I'm happy to allow at this point Mr. Pennington to.
Fine. Well, in that case, if those assisting you can find some examples of a final appellate jurisdiction in the High Court for you to draw to our attention later,
yes, please,
very helpful.
Grateful, my Lord.
Thank you very much, Mr. Rodriguez. Yes, Mr. Pennington.
Thank you very much, my lords, my lady. I think because of the ground that's been covered already, I think I can march my submissions quite quickly, because we, at this level, also accept that there is no court that has an express power to hear appeals from the licensing authority. There's no catch-all provision in any of these bits of legislation that says any other undesignated appeal or anything like that. I was going to go through those bits of legislation and make good that submission, but I don't think I need to, because we've been through them. But basically...
Why does the Transport Commissioner want appeals to go to the Court of Appeal? Why don't they just have a neutral stance on this?
Well, at first instance, I think...
You wanted them to go to the Court of Appeal, all the magistrates, but put the other way around. Why is he so concerned to avoid the High Court then, and either have it lower or higher?
Well, I genuinely think it was simply attempting to assist the court to reach the right decision, so that the appeals go to the correct place. That's certainly my position at this level. I don't, frankly, make any difference to me where they go. I think Hart refers to them as traffic light rules. It doesn't matter whether green means go and red means stop, as long as we all agree that they mean the same thing, and we all end up with otherwise we drive into each other. But as long as the appeals go somewhere and we all agree where they go. But the relevant jurisdictional bits of legislation are the Constitution, sections 99 and 100, just for your note. And then the Court of Appeal's jurisdiction is further addressed in the Supreme Court of Judicature Act in sections 35 and 38. 35 we looked at briefly, just refers one back to the Judicature Ordinance. And the old...
Yes, page references as well.
Yes. So, section 99 of the Constitution is...
It's particularly helpful because I don't think there's an index for the bundles.
Not on the electronic.
No.
So section 99 is 1121. And And then section 100 is 1121, unsurprisingly. And then I've given myself a tab number, unfortunately.
As I understand it, I mean, it's helpful to have these references, but you're saying we can look at them, but they don't actually supply the appellate jurisdiction. So
yes,
you have to get that from section 88M9.
You have to get
however it's properly construed.
Yes, so the judicial ordinance we were looking at starts at 10110, and the relevant provisions are sections 20 that I think we looked at, which effectively grants to the Supreme Court of Trinidad, the predecessor of the current High Court, all the powers exercisable by the High Court, which would have only been original jurisdiction. And then we looked at 32, which deals with appeals to the full court. So in other words, 2 or 3 judges of the old Supreme Court would have sat in an appellate jurisdiction. That appellate jurisdiction is now exercised by the Statutory Court of Appeal, and doesn't, I accept, include some sort of catch-all provision to hear appeals against public authority decisions or any other undesignated appeals, so it doesn't actually take the matter any further. And then I say, same in respect to the civil procedure rules. We looked at those earlier. Part 60 deals with appeals to the High Court. We've looked at that. Part 64 deals with appeals in the Court of Appeal. They share the same powers, although I accept, obviously, you're probably going to get a tougher time trying to get in further evidence in the Court of Appeal than you would in the High Court, I suspect, as a matter of practice. But again, they don't ground jurisdiction. There's no suggestion that there's any jurisdiction in the summary courts to hear appeals, and there is no process either. So inherently unlikely that Parliament would have intended for appeals to go there. I think that's accepted. So that's why we land up in the position where the parties say, well, it's either.
I see. So in the original system, there was just one Supreme Court,
yes,
and your trial would be by a judge, and then if you wanted to appeal, it went to the full court.
To more judges, yeah.
Like in bank, as it were.
Yes, and so I think Mauritius still has a similar.
Some Australian states.
Yeah.
Yes.
Okay.
Yes, and then when that was when the Republic was formed, the previous jurisdiction by the full court went over to the Court of Appeal, and the Court of Appeal deals with appeals. I mean, one point that is a bit uncertain in this case is the extent to which the High Court in Trinidad and Tobago really does hear appeals. I mean, I can see that there's some rules in the CPR Part 60 that deal with appeals.
But you don't know what they relate to?
I don't know what they relate to, and in actual fact, I can't see anything in the Supreme Court of Judicature Act either. And one must bear in mind that, unlike in England and Wales, where obviously there are lots of regional courts and decisions of regional courts, district judges may well appeal to the High Court. In Trinidad and Tobago, you have effectively 2 High Courts, I think San Fernando and Port of Spain, and then you have the Court of Appeal. So you don't have a system necessarily where it's so common, I think it's fair to say. 3 High Courts, are there?
Tobago.
Oh, Tobago, sorry. God, I will not be forgiven for that. And I'll come to make this submission more fully in a moment, but I think it's fair to say it's probably not as common, it's not as routine that you will have significant numbers of appeals going to the High Court in Trinidad and Tobago, as you do routinely have appeals going to the High Court in England and Wales.
But do they have other kind of licensing authorities, like for alcohol in a bar, or to hold a shotgun, or... I mean, here there are all sorts of licensing authorities to operate telecoms equipment.
Off the top of my head, I can't think of any.
Well, here you get appeals now to the High Court from, say, disciplinary disqualification of a doctor or a nurse or a dentist or something.
I suspect...
Or a barrister now, I think.
I suspect that there must be those, because the CPR has a whole part dedicated to appeals to the High Court. So there must be appeals that are heard by the High Court. I'm just sort of positing the suggestion, as nobody can at the moment seem to think of any examples that might not actually be terribly common. In other words, when the Court of Appeal is sitting and thinking to itself, well, where must Parliament have intended for appeals against penalties to go? And the Court of Appeal thought to itself, well, they must have meant us. There is actually, from a sort of interpretive perspective, something in that, because they are there in that jurisdiction and they know how the system works and they have experience of where appeals normally go. And certainly the old appeals that would have gone to the full court of the Supreme Court go to the Court of Appeal, and all the other appeals for criminal matters, as far as I can tell, go to the Court of Appeal. And what the Court of Appeal is effectively saying in this case is, well, look, penalties, this is a penalty. I appreciate you get to that penalty in a slightly different way, although it's not quite as clear-cut as it's been suggested. But it's still a serious penalty. It's a disqualification. And the guttural reaction, if I can call it that, of the Court of Appeal is, well, that must come to us. And that must stand for something, because words in legislation, when we talk about words being given their natural and ordinary meaning, that's a natural and ordinary meaning in the particular society and in the particular legal structure that everybody's used to. So it is not insignificant that all of the judges below...
Well, their reasoning seems to have been that because we deal with appeals from convictions,
yes,
we should deal with these. But
yes,
the argument against you is that they failed to take account of the fact that the nature of the proceeding has changed, and it's not a criminal proceeding anymore. It's now a different kind of decision.
Well, can I just explain a little bit more about the differences between the two systems on that point? Because if one... Let's start with the Court of Appeal decision, paragraph 29, which is at page 268.
This is the bifurcated process point.
Yes, and I appreciate what's been said, and I'm not pushing back necessarily on the point about 88k and so on and so forth. We've been through all of that, but I think the gravamen really of actually the point that the Court of Appeal is making here is really in the third line. It's the same penalties. This is what the Court of Appeal is concerned about. So, under the old scheme, you had courts deciding whether somebody should be disqualified as part of the punishment for whatever offence. Now what you have is a system of people being given... People get points, by the way, for in two circumstances. One, following a fixed penalty notice, but secondly, also following convictions. So the fixed penalty scheme, the penalty point scheme applies to both. I'll come to explain how that works in a minute.
I mean, it's why people talk about civil penalties. I mean, it's the disqualification order is the same, but it doesn't follow upon a conviction.
Well, I'll come to, because it's not quite. I take the point, but it's not quite as straightforward as that. But the Court of Appeal's concern, nonetheless, is that it's and that's also in paragraph 36. It's the seriousness of the penalty. And given the historical context, court of competent jurisdiction for an appeal involving the imposition of a penalty can only be the Court of Appeal. So it doesn't matter, effectively, in other words, whether it's being imposed following a conviction or whether it's being imposed following a streamlined system of fixed penalty notices. The fact is the punishment is of a gravity.
Is that right? Because you wouldn't entrust punishment for a criminal matter to a licensing authority. So isn't what's being done is it's changing the nature of how it's perceived. You're saying this is not a punishment for a crime you've committed. It's just that if you're the sort of person who keeps driving through the red light, you're a danger to other road users, and under a licensing system, we ought to take away your license.
I accept that. I think the point I'm making is that the Court of Appeal, which must also be taken to have understood that, is nonetheless, I say, saying here that the seriousness of the penalty means that it should, as a matter of principle, come to the Court of Appeal along with the same penalty that is applied by courts, because courts still have a...
Or what about if you get your shotgun licence, removed? Say that's a serious thing, then you don't go to the Court of Appeal from that. at least not unless there's something in here that, well, I haven't seen.
I think that's comparing apples and pears. I mean, the point is that at the moment, and this is really the point the Court of Appeal is making in paragraph 29, as things now stand with this new system, there are two ways in which somebody can be disqualified. One is following a conviction, and another is following an accumulation of fixed penalty notices. So if you are punished with disqualification following a conviction, the appeal goes to the Court of Appeal, and it makes sense, says the Court of Appeal, for the same seriousness of punishment, as it were, to also go to the Court of Appeal, given that it all arises from violations of the same provisions, even though one's criminal and one's not.
Well, but you could put the point the other way round and say the seriousness of the penalty means that there should be a trial of any factual dispute there is as to whether that penalty should be imposed. And that would point, in the magistrate's court, there will be that factual investigation and an adjudication on that by a court, but in the licensing authority context, there isn't. And given the seriousness of the penalty for the person, if your cause, your showing of cause is rejected, then it makes sense for it to go to the High Court, which is more used to dealing with that kind of procedure.
Yes, well, I can see that there may be a procedural advantage, I suppose, in having the matter go to the High Court, but both courts enjoy the same powers. But it must be borne in mind that if somebody gets a fixed penalty notice, they can challenge that in the magistrate's court. So they may well have had a trial, actually, on the fixed penalty notice, because they could have contested that in the magistrate's court, and they may have won and they may have lost. And if they've lost, then they'll get the penalty points. So you get penalty points in different ways. You could accept a fixed penalty notice, you could challenge it, but you can also get penalty points following a conviction before a court.
But I think what's being put to you is, if you get your penalty points following conviction before a court, you've had your trial. All the facts have been gone into in the usual fact-finding way by a court.
Yes.
If you have your penalty points via the licensing procedure from the licensing authority, you haven't had a trial. And the first time you're going to get the opportunity to have your trial of what may be highly relevant facts pertaining to mitigation, which is essentially what one's talking about, will be on this appeal to whichever court it is. And what I think is being put to you is that, given that these matters may well depend on matters of fact which need to be tried out, isn't it more natural to think that the legislature would expect that to happen in a first instance court, the High Court, rather than in the Court of Appeal for the first time?
Well, I think as to the first limb of that, I can see, in respect of the particular factual circumstances surrounding the showing cause bit, that hasn't been tried before. But I'm simply making the point that even in the fixed penalty notice regime, you may well have been to court on those individual fixed notices. So in other words, the stuff that you're saying to the licensing authority,
you may have contested the validity of the penalty, as it were. Once it comes to the licensing authority, that is already, that's the starting point.
Yeah, so you may have already challenged. You haven't challenged. So the stuff you're saying, the things that you're saying to the licensing authority at the end of the process, when you're saying, please don't disqualify me even though I've totted up to 12 points, whatever it is, some of those things you may well have already said to a court, because you may well have challenged the fixed penalty notice. But also, and I just want to show your lordships, my lady, this piece, how the legislation works. You get penalty points not just following fixed notices, but following convictions before a court as well. So both lead, points being prizes, it doesn't matter where you get them from. So where do I need to go? So
Well, you can't say before the licensing authority, I shouldn't have got those points, or you know, because that's the starting point.
But you have already
So you can only say
yeah.
it's only mitigation, basically,
Exactly.
that having got those points, you shouldn't take my licence away for these
Yes.
reasons.
So it's potentially quite a narrow, because if you say I shouldn't have got the points in the first place, then the licensing authority will say, well, you should have contested the notice before a magistrate.
Well, wouldn't that be an appeal under a different section from section 88M9 though? I mean, what is an appeal? How specific is the appeal that section 88M9 relates to?
It's just against the disqualification, affirming the disqualification decision.
I mean, if you get the penalty notice and you want to say, oh, the camera didn't work properly or something, I wasn't really going through the red light, then that's when you have your contest in the
Exactly.
magistrate's court.
So it's quite a narrow...
But they don't have any discretion about the number of points, do they? If you lose, then you've got the points. If you win, you don't have them.
Well, that's actually one point I raised with my learned friends this morning, because the Court of Appeal says in paragraph 27 of its judgment that if you challenge a fixed penalty notice, you then have a trial, and actually, if you lose that trial, you can end up with more points than you were originally going to get.
How does that work?
Don't know.
Does it say in the penalty notice, like, you know, if you pay it now, you could pay £30 or something, and you could settle for 3 points, or if you contest and lose, it'll be 6.
I don't know, because I haven't managed to find the relevant provision that gives the Court of Appeal that power, or the Magistrates' Court that power, and that's why I asked my learned friends this morning whether actually paragraph 27 of the Court of Appeal judgments is correct. But the point is, the licensing authority's discretion is right at the end of the process, so you can't run any of those sorts of arguments, or you can't rationally run them, because the licensing authority will say, well, look, if that was your point, you should have contested the penalty notice. It's simply, you've totted up, you've got to 12 points, and therefore there's a potential to somewhat overestimate the extent to which you're going to have a trial on appeal. This is
basically mitigation.
It's mitigation.
It's mitigation. Yeah. And you have to then say to an appeal court, whether it's the High Court or whether it's the Court of Appeal, the licensing authority, which is a specialist authority entrusted by all the sorts of stuff that respondents say to appeals against specialist tribunals, all the things that we say, well, look, okay, it's an appeal by rehearing, but in reality, it's an appeal against a specialist tribunal charged with the responsibility of deciding who should and shouldn't be on our roads as a matter of safety. And you've made all your factual points to the licensing authority, and unless the Court of Appeal or the High Court hearing the appeal thinks that they've gone wrong in some way, the reality is you're not going to ever, are you, have a trial in reality.
But they don't give reasons, is that right?
Well,
Practice.
Well, apparently not, but the practice can't dictate how a piece of legislation is meant to be. I mean,
Well, it will affect to some extent how the appeal is treated, I imagine, because if they're given reasons, then perhaps whichever body it is would say, well, we're not going to interfere with those unless...
Yes. Maybe
if they haven't given any reasons, well, they might be more inclined to have a look at it themselves and think,
Yes.
well...
But it can't affect the interpretation of the legislation. I mean, maybe that the first point on appeal is you didn't give me any reasons and you should have done, and that was all terribly unfair.
Nonetheless, the legislature has seen fit to confer this right of appeal, which is only for a decision under section 88M. So there must be other provisions which give other appeals against other sorts of decisions. But what we're talking about is, I mean, do you accept that what is going to be an issue in an appeal under section 88M9 is going to be, for this kind of thing, whether the person has shown cause why he should not be disqualified?
Well, it'll be whether the licensing authority was wrong to maintain the disqualification, given the points you put forward. It's not a trial. I mean, the legislation hasn't said under 88.9, whatever it is, 88M9, please transfer your case to the High Court for a full de novo factual inquiry into whether or not you should be disqualified. A specialist tribunal has been given the job to decide whether to maintain the statutory presumption that you will be disqualified. And the narrow point before a Court of Appeal or the High Court is, did it get that wrong? I accept. There's no limit express on the scope of that appeal, but the prospect of you having a trial before a Supreme Court, it just seems to be fanciful. Right?
It's a form of sentencing appeal, really.
Sorry?
It's like a sentencing appeal.
It's not, though, because the statute says, look, if you get lots of points, you lose your licence. And then there is a narrow discretion in the licensing authority, if you show cause, to disapply that. And then you have to go to an appellate court that decision was wrong. That is not a trial. That is a short, I should imagine, fairly short 10-minute hearing, saying, well, actually, you know, because their reasonings disclose some obvious error or it's a...
Well, one view of it, you're never going to win, you know, if it's just a sort of grant of mercy, which they haven't, haven't decided to exercise.
I don't suppose the idea of this scheme is that many people do win. I suppose the idea of the scheme is that most people who get 12 points lose their licence.
I mean, just in terms of what the scheme contemplates, you get from the licensing authority, Section 88M4 says, licensing authority, after taking into consideration any facts and mitigation, decides to disqualify that person, the authority shall forthwith in writing notify that person of the disqualification. And then 9 kicks in because it says you may within 14 days of receipt of the notice under subsection 4 appeal. So, I mean, I can see that a practice may or may not be adopted in terms of giving reasons, but actually all that the statute requires is confirmation you're disqualified.
Yes. I mean, there should be.
So that, I mean, it's still... The scheme seems to leave a gap between the contestation of facts and, you know, I understand what you're saying about it really being a clear mitigation, but sometimes facts are relevant to a clear mitigation and there may be a dispute about those facts. And if there is, I would have thought justice requires that you need some mechanism for resolving the dispute about those facts.
Yes, and that's why you have a residual discretion both in Part 64 and Part 60 of the CPR for either court to call in evidence on the issue. But I'm just saying that insofar as Parliament must be taken to have assumed to intended for the appeals to go to the High Court because there's going to be some whacking great big trial in all of these appeals, I just don't think that respectfully that's right. There may be occasions on which the court needs to hear facts and either court will be in a position to be able to hear those facts. It may seem, I accept, perhaps odd that the Court of Appeal has thought that, invited upon itself to be in a position where it would call, but you have to...
say, well, you have said I have to take my child for dialysis, but, you know, I'd like to, then that's contested, and wouldn't so much expect the Court of Appeal then to have the person put in the witness box and a few questions asked, would you?
But that's why I sort of do plea and aid my original point, that is a point that your Lordship makes to me from...
an English perspective.
Yes.
That's true.
Yes, and it's a point that makes sense to me from an English perspective. But in a smaller jurisdiction where the Court of Appeal routinely hears appeals on things including facts, the Court of Appeal didn't think it was odd.
No, but as I put to Mr. Rodriguez, I think you're entitled to say, well, the Court of Appeal seems relaxed about whatever the procedure.
Well, the Court of Appeal seemed to think it was sort of axiomatic. You know, this is. You know,
yeah, but the 2 points against you are first that they were just reading over the old system without reflecting on the fact that actually it had changed materially, and second that they made a mistake in thinking that and attaching a lot of weight to the fact it would lead to an absurdity because you get appeals on the same matter to 2 different places.
Yes,
and that coloured their thinking.
Yes, yes, and if it was. If there were...
I think you accept that they did make that mistake because the point wasn't raised to the Court of Appeal, I think. It wasn't pointed out to them that...
Yes, and it is an answer to the particular concern that you could have these two parallel proceedings and they might not fit with each other, but it's not an answer to the more general point made by the Court of Appeal.
So can I just check that you do accept that the Court of Appeal did make a mistake in its bifurcation reasoning?
In particular, on the point that one could end up in a situation whereby one court is...
The same decision was being made by two different bodies, in
Yes,
effect.
because the effect of section 88K1 and 88K3, I think we've discovered.
It was two and three. Three in particular.
Yeah, is that can't actually happen.
But I think
in substance, there's a suspension.
Yeah.
Yes.
Until if you pay the notice, you're not going to challenge it, and then the points are imposed on your licence.
Yes.
But if you contest the notice, that means that you're swept into actually a trial against you of the underlying offence, I think, is the way it was working.
Yes, but
Which actually is why
sometimes these things are called an alternatives to prosecution.
Yeah.
And if you don't take that alternative, then
you're prosecuted.
You're prosecuted.
Yeah.
Which actually is why I rather thought that the Court of Appeal in paragraph 27 might well be right in terms of...
they may well be. Indeed,
because after you've had a trial, I don't know...
Well, it's somewhat unusual to say that it's 3 points if you admit it now, but 6 points if you contest it. I can see that with the fine, but...
Don't know, it happens
Anyway.
with guilty pleas all the time. So, anyway, we
yes,
don't need to get into that.
Make our life easy and take the notice, or you'll end up in court with a conviction. But my own friends say that in practice...
But the idea of a fixed penalty is that the number of points is fixed, I thought, and it's not...
Well, I know, that's why I asked the question that's why I asked the question this morning. How can you get...
But anyway, my question was, do you accept that the Court of Appeal has erred?
I accept, yes.
Okay.
So but what I say is there's actually an interior, more general point that is a good point, which is made in paragraph 29, or
At the beginning of it, you said.
the beginning of it, which is
It's still a penalty. It's serious.
it's serious, and
Those are reasons why one would expect it to go to a Court of Appeal on appeal.
if under the old piece of legislation the appeal went to the Court of Appeal against that serious penalty, then when you have a new body making that same decision, which can also be a decision, by the way, following a conviction, as I said, you get your points not just from fixed penalty notices, but also from convictions, then it becomes effectively a punishment following a conviction in some cases, and therefore why shouldn't that also go to the Court of Appeal? Can I just, that stage, go to the old, or the Act as it was prior to 2017.
Does the Trinidad Court of Appeal have different civil and criminal divisions?
Sides, yes. So civil sides and criminal sides, yes. And this,
And which side do you say this appeal goes to?
I think it probably would be the civil side, yes.
The civil side.
I think so.
So there's that changed at any rate from the old system?
Yes. So the Road Traffic Act, as it was, page 470 of the bundle, paragraph, section 82, the court before which a person is convicted of any offence in connection with the driving of a motor vehicle may, in addition to any other penalty, be disqualified.
So sorry, which provision were you looking at?
82.
Thank you.
The bottom of page 470. So this has been repealed, but this is what was in the old Act.
Right.
Sorry, same Act, but in its previous incarnation. So there was a general power in any court, which could be a magistrate's court, could be a high court, depending on the offence, to disqualify persons following a conviction. And then on the next page, section 83, a person who, by virtue of an order under Section 82 is disqualified, may appeal in the same manner as against a conviction. So that's where that wording has been used before, as we've seen in 88H. So that's why I think the Court of Appeal is saying, well, look, under the old scheme, the court would have this additional power in addition to whatever penalties are set out in the substantive offence, which may include disqualification but may not include disqualification. If they don't include disqualification, nonetheless, there's this catch-all that's tagged on where the magistrate court, or let's say the trial court, can then also disqualify someone, and you get a right of appeal against that extra punishment to the same court as you would have appealed the conviction, which would be the Court of Appeal.
There's nothing conferring a right of appeal because it's already part of the scheme, is that right?
Well,
Oh, may appeal. It's 83 is. Oh, it is creating a right of appeal.
I
Yes,
think so.
yes,
I mean, it says may appeal in the same manner.
Yeah.
I mean, so it talks about the same manner, but I do think,
so that is, yeah.
but
I
actually,
mean, in effect, when it says in the same manner, it identifies the body that's going to
I think so.
be the proper target of the, the forum for the appeal.
The reason I say yes, the reason I'm a bit equivocal is because even without Section 83, I would have thought that 82 would have been treated as part of the sentence and therefore swallowed up within a general right of appeal against your conviction and sentence under the summary, under the whatever. But anyway, I mean, yes, I think it's intended possibly
To make it clear, anyway.
to make it clear, and possibly also to make the point that you could just appeal that bit.
Yeah.
So you may say, all right, well, I'm banged to rights on my conviction and my fine, but I do want to appeal my disqualification. So the point is you then end up in the Court of Appeal on a disqualification-only decision. And yes, there's a conviction in the background, but you're not actually before the Court of Appeal challenging any of that. You're simply challenging the disqualification. And I think what the Court of Appeal is saying is, well, when that power, because these powers were removed by the 2017 Amendment Act and replaced with the power of the licensing authority to disqualify, or more, I use that shorthand, but you know what I mean, it's actually a deeming provision that's then disapplied. But so the Court of Appeal is saying, well, hang on, if these, well, I don't want to attribute too much to the Court of Appeal, but what I'm saying is, if you could have appealed a disqualification order simpliciter to the Court of Appeal beforehand, then it's sensible to think that Parliament intended you to have that same right under the new scheme, because although the body that imposes that punishment's changed, it's the same punishment.
And also, I'm just thinking back to the days when I had to do this sort of thing, sitting in a criminal appeal court. You build up there's a body of practice that builds up as to, how do we deal with taxi drivers? How do we deal with ambulance drivers? How do we deal with the man who has an urgent call of nature? How do we deal with the pregnant wife? And you would want, there's a benefit in having a consistency in the practice of the court, which is going to be diminished if you have different courts dealing with these appeals, depending on whether they come to you from the licensing authority or from the magistrate's court.
Yes, well, I'll just gobble that submission up for myself, if I may, because that's a good point, if I may respectfully say so. And I think that may be when the Court of Appeal is saying in paragraph 29, it will be an anomaly for appeals of traffic ticket matters to proceed to the Court of Appeal, while at the same time appeals from the authority imposing one of the same penalties would lie to the High Court. Maybe that's in that thinking somewhere.
And I wouldn't exaggerate it, but it's not as if there are principles of law being applied. But nonetheless, it's a good idea if there's a degree of consistency in approach.
Yes, I think what I would also readily accept is that once one accepts, as we do, that none of these bits of jurisdiction legislation actually help in terms of deciding what in Parliament intended, and you're simply looking, as it were, at a pure construction of the 2017 Amendment Act, one is actually looking at some quite narrow points either side. In other words, I don't say that one couldn't muster up a decent argument to say that the appeal could go to the High Court. I accept that. But in the end, the question is whether the factors that the Court of Appeal identified and which it thought were important, and one of them is, well, listen, this is the sorts of stuff that we deal with effectively. That's enough. Because when it's very finely balanced, and every single judge, as it seems below, seems to think that the obvious answer was the Court of Appeal, in a finely balanced case, that may well be enough. Anyway, so 82 and 83 are then repealed. Then what happens is, so the general power of a court to disqualify goes, but there are still several provisions, there are still several offences where the punishment includes disqualification. So, for example, Section 62
There are not, just looking at the old sections, run of sections 86 onwards at 474, some of those, like fraudulently applying for a driving permit under the old section 88, is now, I think, part of a run of sections going up to, is that part of section 88M now?
I don't know. I'd have to remind myself whether it is, but
I would have thought that the way the court looks at a challenge to disqualification may depend quite a bit on the nature of what's given rise to it. I mean, if you've been disqualified for causing death by dangerous driving, it might take a rather different view from if you've been disqualified through not wearing a seatbelt on a couple of occasions. You know, what might count as a good excuse in one case wouldn't in another.
yes. I accept that.
But you're saying there are some provisions where you get an automatic disqualification.
No, I'm simply...
there are, just like there are here.
I'm simply saying, for example, section 62, which is at 441.
Or you can get, yeah.
Yeah, so it's section 441, page 441, and then on to page 442, subsection 5. Any person who drives a motor vehicle on any road in contravention of the provisions of subsection 1 is liable to a fine and to be disqualified. I think liable must mean could be as opposed to will be. But so there's a discretion there in a court to disqualify somebody. So although the general section 82 power to disqualify has gone, there's still other instances, is the point I'm making, in which the court may disqualify someone, and therefore there will be, as the Court of Appeal rightly held, other disqualification cases in the Court of Appeal. And that's the simple point I'm making. There are a number of different examples of that. And then there are also, but there are some offences, for example, section 21, which is at page 420, there doesn't appear to be any power in the court to disqualify for those offences expressly. So under the old scheme, the magistrates' court or the trial court, which would have had the old discretion under section 82 to disqualify somebody, but that's now gone. So what happens instead is if somebody is convicted under Section 21, the court doesn't disqualify them, but the licensing authority applies points. So this is just one example of several. I'm just picking on Section 21. So under the new scheme...
Is it an automatic number of points, or do they decide how many?
It's an automatic number of points, and we're back into Section 88K, which is at 836. So I think how it works is you are convicted under Section, say, 21 for an offence, which doesn't include a power to disqualify in the court, but which used to attract the discretionary power to disqualify under Section 82, doesn't anymore. But then what happens is Section 88K applies, and it says where a person is convicted of an offence or a traffic violation listed in the first column of the 9th schedule, the demerit points in the 4th column in the 9th schedule shall be recorded against the driving permit record. I assume it's the licensing authority that has to do that task, but there's no discretion. And then...
sorry, do you have the page number for the first column of the 9th schedule?
Yes, so we're going to that now. It's at 845. And at 845, one can see in the first column, using or altering a motor vehicle or a trailer for a purpose not authorised. And then the second column, Section 21(1)(b), which is the provision we've just been looking at, and you get a demerit points of, you get 3 demerit points. So under the old system, you would have been convicted for that offence before, say, a magistrate's court. The magistrate's court would have had a discretion to impose a disqualification. That's now gone, and what you get instead is demerit points, which obviously isn't a disqualification, but if you get enough of them, it is. Yeah. So the point is, under the new system, in effect, some of the court's power to disqualify people following convictions is now replaced by a system of fixed penalty points, which can lead to the same punishment. But it's not right to say it's a completely civil system, because you still can accumulate the points in the same way, i.e. following a conviction, but rather than a discretion of the court, it's now actually just the system. You just get the points that there are in the schedule, and then at the end of it, there's a little bit of discretion to let you off if you make a good case out.
So am I right in thinking that all the offences that are listed here, they're sort of more at the minor end of traffic offences? I mean, do we find death by dangerous driving or something like that? Yeah.
Well, that won't attract points, I don't think. That would just attract automatic disqualification, perhaps, for...
That's what I was wondering. Yeah. Is there some system where you're either a court has a discretion to disqualify you, or there is an automatic disqualification on conviction?
Well, so for example, if one goes on to 849, I think the answer is broadly yes, because the very serious offences, manslaughter and things like, or death by, what do they call it, causing death by dangerous driving, that is one where disqualification is an express power of the court. So you don't get into penalty points for that. If you kill somebody, you don't get a penalty point. You just go to court, and it's a trial and indictment before a high court, and disqualification will be one of the many things, no doubt, that happens to you. So yes, I think my Lord tells you you are right, that it is, I mean, still drink driving and stuff like that. They're not unserious.
Yeah, absolutely. I mean, some of them are very, potentially very serious.
Potentially serious, but they're not the most serious, because the most serious have the express power of disqualification. But the simple point that I'm making is that it is not correct to say that the new totting up system is devoid of any real connection to the criminal system. And therefore that adds weight effectively to the Court of Appeal's inclination that Parliament probably, on balance, intended for the appeals to go to the Court of Appeal.
Were there points before? Sorry, I haven't quite followed. But now what's happened is that it's fixed penalty notices, or is points a new thing?
I think points is a new thing, but what I did notice under the Act as it was, Section 86A, which is at page 472, provided, even before the amendment, provided the licensing authority with a power to suspend licenses for up to 6 months if the licensing authority formed the view that it would not be in the interests of public safety for the person to hold a driving permit. And then under subsection 2, provided the power to prescribe regulations and a system of awarding penalty points. And then there are further provisions on page 473 of the bundle about how those regulations might look and what they might deal with.
Well, how did you challenge the decision of the licensing authorities to suspend your
Then it would be exactly the same on page 474 at section 86B, subsection 4, an appeal to a court of competent jurisdiction.
Thought we were going to get the answer.
Sadly not. So I think the answer to my Lord's question is there was a power to introduce a penalty point system, but as I understand it, I've looked at the regulations that were promulgated before 2017, and that invitation just wasn't taken up, so there wasn't a penalty point system.
No.
Is that right?
That's correct.
Yeah.
And the question never came up about what the Court of Competent Jurisdiction...
Therefore, the question never came up, exactly. So...
Now, Ms. Penny mentioned we've all been enjoying ourselves so much we haven't noticed the clock going past 1 o'clock a few minutes ago. Is this a convenient point for us to adjourn?
I'm very happy.
Very well. Well, we'll adjourn now and sit again at 2 o'clock.